Preston, good to see you. Thanks for coming in.
Thanks for having me. It's a pleasure.
Yeah, awesome. So let's do a little bit of origin story. I think you and I met maybe 2014. I was at Digital Asset Holdings, and you were doing maybe early 15.
Yep.
And you were working on marmots.
Yeah, so we were working and so it was a startup called Eris, and then we got sued by Eris Exchange, so we had to change it to Monax, which is the scientific word for marmot. And Monax, what we did is the banks were all stupid when it came to blockchain stuff. We thought that there was an unanswered need on getting them involved with decentralized tech, and in particular smart contracts. So what we did is we built a bunch of smart contract prototypes. We did the first one for Swift, the first bond for Deutsche Bank, and rather than looking at blockchains as something where you have very small, light smart contracts and tokens, right, that move around in those light smart contracts, we said, you know what, we can actually turn this into a 100,000 line application, right? And then what we can do is we can share the execution for really complicated things between financial institutions like securitizations and bonds and things like that. Company didn't exactly take off because that's like really complicated. It's like, hey, go use this like really experimental, fork of ETH PUBKey in order to automate your tech stack. And they're like, and what's the benefit? And it's like, well, you won't be able to charge as much in fees. So they really didn't like that. So
we had similar conversations at Digital Asset Holdings back in the day where they're still around, but many such cases. They haven't done that much. They have the Canton network with Circle, and R3, I think, is still kicking around. It raised a shit ton of money. What brought you to Monax and Eris? Like, what was the background that led you to that, developing that concept out?
It was actually a contest. So the guy named Olivier Janssens didn't like, after Brock Pierce was elected to the board of the Bitcoin Foundation, he found that offensive. And so what he did is he announced a contest to automate the Bitcoin Foundation. And so there were two entries to that contest. One of them was, I can't remember the guy's name. He rage quit Bitcoin like back in 2017, sold all his coins. I can't remember his name, but he created a fundraising app called Lighthouse. And then it was a crowdfunding app on Bitcoin. And we took an Ethereum proof of concept and turned it into a DAO, right? The first DAO prototype, so to speak, where you could vote and you could have tokens held in certain balances and things like that.
This predates the bicycle lock DAO?
Oh yeah. This is a year before that. So this is actually it's 2 years before that. So this is June of 2014. And we published a white paper, a blog post, right, explaining what we did. And then we got a phone call from some London, Canadian VC based in London, Surfer Bro, who was just like, he ran a group called Anthemis Capital. And he was just like, Sean Park is the guy's name. So he called up and was like, hey, how would you like $1 million to turn this into a business? And I was working in Big Law at the time. And I was just like, okay, where do I sign up? Let's go. And so went into it, had no idea what I was doing in terms of running a startup or product market fit or anything like that. But it was a very interesting learning experience. And as a result, it meant that I got to, meet everybody in crypto, make a lot of friends, and some of the friends I made then are my clients now. So it was really totally worth doing, even though it was completely insane and everyone thought I was just totally out of my mind for trying to do enterprise blockchain. I think we were the first permission blockchain. People gave us a lot of stick for that, but it was still worth doing, right? Even though we failed. So it was fun. And now, that led pretty much to everything.
Wait, marmots first. What's the deal with marmots?
They lived in my yard, marmots, groundhogs specifically, and they became my spirit animal because the stress of running a startup was so awful. And dealing with like corporate social media accounts where people were like, your product sucks, like everything's Bitcoin, you need to have like, why are you doing permission chains? You're terrible, like shitcoin or whatever. Blah, blah. That I just decided to start posting pictures of cute animals, and marmots kind of was where my attention got focused. And it was a hook, right? Because when you're trying to explain, we have this really complicated startup and we can't really explain what it does or what it's going to be useful for. And we think there will be some marginal efficiency gains for these really obscure types of financial transactions that only 100 people like know how to do in any given city. And that's what we're building. You need something else for people to hang on to. Right? And so the marmot wound up becoming that thing. So we had Marmot logos. It was punk rock Marmot. We named, we had Marmots in the command line, in the CLI, for the thing. If you had an error, it was like, oops, the Marmots is like dropped all the blocks. You need to start all over again. And so that's it was a fun little thing that we did as a marketing tool, but also just fun, right? And so that's why we kept doing it.
And you're involved with you were involved with an organization for marginalized marmots.
Yes, I wasn't involved with them. I tweeted about them a lot.
Yeah.
Called the Marmot Recovery Foundation. Okay. And they saved the very adorable chocolate brown Vancouver Island marmot in Canada from extinction. There were only 20 individuals in the wild. Now there are close to, I think, like 700. Oh, great. So basically, they brought this adorable little fuzzy species.
Chocolate marmots.
Yeah, chocolate covered marmots with little white noses. They're adorable.
Okay, there we go. Yep. We'll try and drop that in the link if people want to donate to
marmots.org/donate.
There we go. Yep. Thank you. All right. So that goes until when? Like 17, 18?
17, 18. So then I left the startup. They wanted to do an ICO, and I wasn't keen to do that. That wasn't my thing. So 2017, I left the UK, left the startup, moved back to America. And at the time, I was an English qualified lawyer, even though I'm American. And so I went back to law school, requalified as an American lawyer, took the bar, and then couldn't get a job anywhere because everyone was like, your profile's too weird. We don't understand what you do. And I was like, all right, fine. Then I'll just.
And what were you specialized in before?
I was a corporate, I was a general counsel for startup, right? So before that, I was a banking lawyer. I then became a GC for a startup. My own startup, right? Mm-hmm. And then everyone's like, well, so you've worked for yourself for this many years? Like, we don't know where to place you. So I said, okay, well, to hell with you guys. I'm just going to go start my own firm. And now I'm a partner. So tough. And I've kind of been doing that ever since. Yeah. Because when you're a partner at a law firm, you have your own business, you run your own book. Yeah. Right? So you have your own clients, you do whatever comes in the door. And it's not something where, if you're at a big law firm, generally you'll hyper specialize. I tend to be someone who goes very hyper generalized, right? So if someone comes in, they say, I have this universe of problems, and then I quarterback where all those problems go. Which is what I do now, essentially. So I started doing that, and then have been doing.
Did you do a JD or an LLM to
LLM?
LLM. Yeah. What was there a particular focus?
Not really. They have these U.S. law LLMs.
Okay, I see.
I wrote my paper. There's a paper requirement. There's a comparative essay on threads of post-Marxism and European free speech discourse. And so, we can talk about free speech is one of the topics we'll talk about. Yeah,
absolutely. We're getting into that in a second.
I've been active in that for a while, but that was part of my practice as well, because I started representing companies that had First Amendment based content moderation policies. And because they were being threatened with destruction essentially at the time. So those are my first clients in private practice. Were companies that had very broad moderation policies, and and the United States government and also big tech companies wanted them deplatformed and destroyed. And I felt that was poisonous to American society to allow that to happen. So those were my first clients, and also crypto clients. So about, I'd say 25 to 30% of my practice was social media oriented. And then the remainder has been crypto transactional and crypto general counsel. Just a guy who knows crypto really well, and therefore knows basically who to pick up the phone to if someone in crypto has a problem. Yeah. So
we buried the lead a little bit without talking about why you're here and what we're going to be talking about tonight, but it's okay because we chop it up and it becomes 20 seconds anyway at a time.
Perfect.
But we're going to be discussing a lot of these public forums and boards and platforms, and I think you've been in kind of a hot spot, not a hot spot, but you've been on a very hot topic lately with the UK sort of trying to export some of the social media censorship that's going on domestically in the UK, particularly with American companies that you represent. I don't know if you want to name the ones that you represent.
Yeah, sure. I represent every single American target of the UK's Online Safety Act, and I'm doing all of that work free of charge, pro bono. Wow. So there are 4 targets to date: Gab.com, social media network; Kiwi Farms, a discussion forum; a mental health discussion forum called SASU, or Sanctioned Suicide. It's a mental health forum for suicidal people, and also 4chan, right, which requires no introduction whatsoever. And the story is the UK enacted this censorship law. They've been working on it for about 5 years, and I've been talking to the UK about this directly for about 3 years. And they called me up in 2023 and they said, listen, you Americans, we're going to have this new censorship law. How do you plan on complying? And I said to the senior director at the Home Office, nice guy, really polite conversation. If you have a conversation with an English government official, even if they're absolutely trying to wreck you, right, they'll be exceedingly polite about it. It's one of the nicest conversations I've ever had with a government official who wanted to destroy one of my clients. And I said to him, listen, my client's not on the phone here, but I can probably tell you what he would say. And they said, well, what's that? And I said, well, they'd probably tell you that you would need to successfully mount a ground invasion of the United States. And at that point, they'll be using their Second Amendment rights in addition to their First Amendment rights. So good luck. Right?
Yeah.
So in other words, so, and we didn't hear.
What was the response? What was the very polite response?
Okay. We'll be in touch. So then 2 years pass, right? And then 2 years later, they start going after American companies. The first one was the Mental Health Forum, which I personally have struggled with representing because I'm a Catholic and the subject matter is.
Why is this? Can we go into why it would be controversial or something that needs censorship?
Sure. So it's a mental health forum for suicidal people to be very honest about their feelings about why they want to die, and so that is something which suicidal people and people who are mentally ill, are human beings just like anybody else. They have the right to talk about their feelings and express themselves. And in the United States, that right is protected by the First Amendment to the U.S. Constitution. In the UK, however, they have a very different approach for controversial speech. They view that speech, they view human beings as not having agency, and they view that speech as being so harmful to people who see it and hear it that it must be extirpated. It must be completely destroyed and snuffed out and removed from the internet in order to prevent the ideas from spreading, right? Because they say, well, the forum has been linked to lots of deaths, right? And that's the argument that they make, that people who are suicidal, sometimes kill themselves. I'm like, well, it is a forum for suicidal people. I think net correlation does not necessarily equal causation.
Yeah.
But the UK's position is that the forum is responsible for the deaths, when in fact it is providing simply a forum for people to talk about, what they're going through and what they're feeling. And at the end of the day, they're not violating any US laws. They're obeying all US laws. And the same arguments apply for all of the other 4 targets that they've selected. So Gab is a political forum where, generally speaking, right-wing thought, some of which is unlawful to express in the United Kingdom, all of which is lawful to express in the United States, is expressed. 4chan, same thing. Kiwi Farms, same thing, right? They're allowed to talk about stuff that in the UK would invite a potential criminal investigation or criminal sanction, but in the because they don't have free speech in the United Kingdom, they will say all day long, oh no, we do, we have free speech, but, right? But the but is the critical piece, is that there are huge categories of expression which can be enforced against on a discretionary basis by someone who disagrees with it. So these 4 targets were selected. They've kind of been they were all the little bête noirs of the sort of NGO space in the United States and the UK for years and years and years. They couldn't get shut down. US activist organizations briefed against them and tried to get them deplatformed and got them kicked off of every internet service, then got them kicked off from every internet service provider, and they just kept coming back. And then the UK enacts its new law, and it targets all 4 of them, all American, immediately, right? And it says, okay, guess what? We've got our new law, we've got our new club, and we're going to start beating you over the head with it. And so at that point, you know, as a practitioner, you have to make a decision, right? These are the most, I will never work in a big law firm again because I've done this.
Same.
Right?
For different reasons.
For different reasons. But I will never work in a big law firm again because I took on these 4 clients at this time with this purpose. And most big law firms were telling their clients, large tech companies, this law is inevitable, right? This censorship law that you're going to
coming to the US.
Coming to the US is inevitable. Mm-hmm. You're going to have to comply with it. And I looked at it and I said, no, this law must be destroyed. It must be destroyed. It must be defeated. It can be defeated, and we're going to be the ones to do it. And so what we did is, you know, all 4 clients, you know, got in touch. A strategy was formulated. The strategy was, you know, depending on which client, different strategies were employed. And basically it was that we were going to refuse the requests, right? So because they're not legally valid in the United States, the orders that we're getting, they're sending them by emails. They're not trying to domesticate them in US courts. They're not using the proper international procedures to get those things domesticated. They're just sending letters, right? And letters are not enough. Letters from a foreign government are not enough to get an American to lose their freedom, right? Mm-hmm. Period. That's just not how it works. And so we then started a strategy where we were going to try to goad the UK regulator into doing something very, very stupid, right? Which they have since done, which is that we wanted them to say that they were going to use sovereign immunity as a defense. And then we were going to take that admission, and we were going to get laws enacted here in the United States. And there's actually breaking news today, right, that we can talk about that.
Yep.
And we were going to get laws enacted here in the United States that would act as a shield from that behavior from ever repeating itself. And those laws would do the following. The first one is they would confirm that UK orders are not enforceable, or foreign censorship orders are not enforceable here. The second one is they would prohibit state agents from cooperating with the enforcement of those orders. The third is that it would create a cause of action for American companies to get injunctive relief, right, restraining foreign censorship, and also civil lawsuits, right, could be brought against these foreign censors with titanic levels of damages. And fourth, it would take away sovereign immunity, which the UK has claimed. In a filing today they made in the District of Columbia, they intend to raise as defense against those lawsuits. The reason this all works, of course, you're like, well, you're suing a foreign government. I'm like, well, I'm a Bitcoiner, right? So I understand. I understand.
Sounds fine to me.
I'm a Bitcoiner. And what do Bitcoiners know? Bitcoiners know that the entire global financial system is a giant house of cards and a giant scam, which runs out of the United States and its banking system. And so as a result, all of these countries have titanic quantities of assets in the US financial system, right, and in US banks, which can be reached by US plaintiffs if sovereign immunity is taken away, in order, right, to seize those assets to satisfy a judgment against the foreign country. So they're vulnerable. They're not judgment proof. And so the news, right, is that today, right, I'm advised that this happened today. I have to get it confirmed, but it's either today or tomorrow. We drafted a foreign censorship shield law. We call it the Granite Act because the plan was hatched in New Hampshire.
Yep.
That stands for guaranteeing rights against novel international tyranny and enforcement. And the first bill either is going to be filed imminently or has been filed today in the state of Wyoming, which creates all those rights for citizens of Wyoming. We were also planning on getting a carbon copy of the Granite Act enacted in New Hampshire. And we have 3 state representatives who are working on that. A very senior member of the GOP caucus is leading it in that state. And basically what we're trying to do is we're trying to prompt federal action, right, in order that the feds would get involved. And we're hoping that by seeing that when the states start doing this, there's absolutely no pushback and it's widely supported, that will prompt the federal government, for which I understand this is a fairly major pain point in trade negotiations, to get off its duff and start getting legislation through Congress. That would be the Senate and the House. So there hasn't been any federal action, not yet, but hopefully we will see some. And then we think that with that suite of rules, American tech companies, large and small, so we're saying, listen, any infringement of the First Amendment, right, invites this lawsuit. And the lawsuit is, the damages calculations that Wyoming will be proposing are titanic, right? So per threat, so it's when you sue, you get the greater of triple 3x actual damages, or $10 million per threat, right, per instance that a threat is communicated by a foreign government or foreign censor, or 3 times the size of the foreign fine. And in the UK's case, the foreign fine is 10% of their worldwide revenue. So if they went after Facebook, worldwide revenue $164 billion, Facebook would be able to sue them for $49 billion. And that's nearly the totality of all UK sovereign assets custodied in US banks. So it basically...
Quantify that for some of your clients, though. Let's say like 4chan, who's been attacked the most?
So 4chan's been attacked the most.
Yeah.
They've received 6 letters threatening them with various things.
Okay.
So that'd be $60 million.
Yeah. Yeah.
That's a great deal.
That's a great deal.
I do that on contingency. Hell, then I retire and I get myself a boat. But
it works.
It's about creating incentives for American lawyers. There are a couple different ways you can.
Also the precedent, right? It's a common law system.
Well, not precedent. This is a statute that we're proposing here, right?
Yeah, I see.
So, but there are a couple different ways we can do this. You can keep asking the State Department to do visa bans, right? And they change every 4 years and the foreign state doesn't really care. You can try pushing on Congress to do little changes here and there, whatever else. That doesn't really work. Or you can say, you know what? We have a law that's going to outsource this to the most ferocious, it is the most fearsome force in the universe other than, space-time or, other than space-time or compound interest, which is American trial lawyers. And we're going to rely on them to figure this out. And I think if we do something like that, the censorship requests inbound to the United States will stop overnight. It will also have an impact on other things like encryption or AI, for example, AI regulation and controlling what US AI companies can do. And we'll say, listen, the First Amendment works. If you want to mess with it, go ahead, right? Yeah. But you're going to have a lawsuit in a US federal court, pretty quickly if that's what you decide to do.
Jesus, this is so cool. Touches on so many different things. This is going to be an awesome talk downstairs, but for folks that aren't able to make it, I want to unpack a couple of things, and I'll let you pick where we should start. First Amendment protections within the United States, and looking at what's happened in the UK and how it can be ported here. Mm-hmm. And there's a couple of different ways that I can frame that. So Twitter abroad complies with foreign governments' rules, right? It's an American company providing a service in, let's say, China, Iran, whatever. I don't think they're in China or Iran, but you know what I mean. And whether or not that protection is available to them. And then also domestically, we've seen some concerns around deplatforming. I think it's lessened quite a bit, but I would love your perspective on, the transition from Twitter to X and some of the, apologies made by Zuckerberg around like COVID-19, and whether or not we're facing some of the same things through private companies and soft pressure. So those are two, broad bucket categories that we can talk about there. But
I think we start with the second before going to the first. I mean, the First Amendment is enormously broad, right? Mm-hmm. It protects all kinds of expressive conduct, right? So think about anything that's about expressing an idea, right? In tangible or intangible form. Generally speaking, the First Amendment is going to be involved in one way or another in protecting that. So writing source code, for example, right? That's First Amendment protected activity. Publishing source code, running source code, provided you're not, doing so with some type of intentional criminal purpose. Now, the First Amendment also protects people's rights not to say certain things. You can't compel people to speak. So with deplatforming, I think free speech is a relevant consideration, but ultimately the First Amendment protects a private company's right to serve someone or to not serve someone, to host speech or not host speech. So I would prefer to see a world where private companies aren't forced to deplatform people, right, by third parties, but ultimately they have the right to do so. And so that's something where, from a lawyer's perspective, you don't want to interfere with that too much. You want to suggest, if they can, listen, free speech is good, open exchange of ideas is good. Please try to not ban ideas right and left, but ultimately it is their call. In terms of the porting the UK's speech codes into the United States, the Online Safety Act is very expressly designed to do that. In the UK, offensive speech is outlawed. Speech which is critical of the government in certain respects is outlawed. You can ban mention of certain organizations. So there's a group called Palestine Action in the UK, which has been prescribed as a terrorist group. And what they're doing is they're arresting thousands of people at a time for simply standing peacefully in Parliament Square, holding up a sign saying, "I support Palestine Action," right? So they're just sitting there holding the signs peacefully in public, on public property, and they're being arrested and charged with 14 years in prison for violating the Terrorism Act as a result. So the UK is really very, very close to a totalitarian state. It's a soft totalitarian state, but where it's very, very gentle, right, or relatively speaking, gentle in how it uses its powers. But if you fall within the the class of targeted individuals, they'll come down on you extremely hard, right? And that's any speech which the woke stuff that we had in the United States. If you go out of line and you start talking about woke topics in the United Kingdom, chances are good that you could draw an arrest. Now, it's not as bad as it was last year, but it is way worse than it was 5 years ago and 10 years ago and 15 years ago. The laws have always been on the books. They've always been broad, but now they're really being very much overused in discretionary fashion. And the Online Safety Act says that if you don't censor that speech sufficiently, right, you'll get fined. If you don't explain your content moderation practices and how you are going to comply with the UK's content moderation regime, you'll get fined. If you don't respond to our notices when we make requests for information of you, right, which you don't have to comply with a request that's sent by a letter. You have the right under the Fourth Amendment to say, come back with a warrant, which is exactly what we did. The UK says we're going to jail you if you don't respond to our information notices when we send them to you. So they're trying to use these crazy laws, right, that they have domestically, and they're targeting the companies that utilize the protections of the First Amendment maximally, right, to operate. These four companies that I represent, really the only country in the world where they could operate is the United States. And all of them, right, have referenced free speech in one way or another as part of their raison d'etre, right, the purpose for their very existence. And they were selected, right, as the targets of the UK's Online Safety Act. When Ofcom, the Office for Communications, their speech enforcer over there, sent the fine confirmation notice to us, they said very clearly the purpose of this fine. Firstly, we don't think that U.S. law protects you on U.S. soil, right? We think our laws apply on U.S. soil. Second, we don't think the First Amendment protects you from us, right? The First Amendment doesn't apply to us because we're a foreign government. That's not true. A foreign government trying to enforce that orders here in a U.S. court is absolutely subject to the strictures of the First Amendment. And they said, and third, the purpose of this fine notice is to, deterrence. It's to show other Americans that if you don't do what we want, you're going to get in trouble. You're going to get fined. You're going to get threatened with criminal penalties. And our answer to that, to be blunt, was fuck you.
Yeah.
Fuck you. Like we don't, and sorry for the profanity, but like,
it's okay.
But like,
it's a bar.
It's a bar. Exactly. And we won a war over this, right? Where we don't answer to you. Right?
Yeah.
We never have. And we never will. And so what we did is we have been prodding and goading and provoking and taunting them into making admissions like that in order to demonstrate to American legislators. Because obviously when we sued, so 4chan got this notice over the summer on July 25th. The UK said to 4chan, we're going to fine you. Or I think maybe it was the first week of August. And we responded by saying, we're going to sue you in DC federal court. And 2 weeks later, that's exactly what we did. Now, when you have a private company, right, going up against an entity which is, close to, if not a sovereign instrumentality, there's sovereign immunity is a big issue in that case. We've made some submissions. We're expecting they'll make some submissions as they're entitled to do. But we knew we had to demonstrate, right, that lawsuit was not going to finish the fight, right, because it was only going to be a precedent for that particular case in that particular set of circumstances. So I've been rather unconventionally for a lawyer, have been needling both the United Kingdom's politicians, the agency in question, the NGOs that support them, all online. And the reason for that is to get them to make politically damaging admissions here in the United States that I could go take to legislators, both federal and state, and say, look what's going on. This is what they really think about us. And so the fact that we've managed, so their notice to 4chan, their fine decision came down on October 13th. Today is currently November 18th. Mm-hmm. So we then published a version 0.1 of our Granite Act censorship shield on October 18th. 30 days later, it's being introduced as a law in Wyoming and on the way to being introduced in New Hampshire. So the U.S.
What are the chances in Wyoming? How does it look?
75, 80%. I give it very good chances.
That's amazing.
Well, and once you have that in Wyoming, guess what you can do? Well, the law also covers servers in Wyoming. It covers people in Wyoming. It covers corporations and LLCs in Wyoming. Yeah. So you can reincorporate in Wyoming, right? Yeah. And guess what? You can then tell the UK, go away. We're not listening to you. You could run a server in Wyoming and you could say, sorry, we're protected by the Granite Act because we have a data center in Laramie and we're running this application out of Laramie. So even one state, right? And we get 50 bites at the apple to make this work. But if even one state enacts this rule, we'll have done a fairly incalculable damage to the Online Safety Act's ability to operate against American companies. Yeah. Now, what we want to do, right? We don't want to just do incalculable damage. We want complete
annihilation,
utter annihilation, total destruction. And that requires multiple states and it requires the federal government. Now, the federal government hasn't moved off the plate yet.
Why do you think that is? Has there been a big push yet? Or is this like a back burner issue for them?
I don't think it's a back burner issue, but it's a big ship. And it takes a lot of time for big ships to turn. So, we are part of the reason we're doing what we're doing at state level is to demonstrate to the federales that it's safe, right? That you can do this and you can talk about it in public. And, because they don't want to do something and then find out, oh my God, we've been engaged in lots of, like the Online Safety Act, right? Where they enacted this thing and then it turns out the law is completely insane and it doesn't work. They want to see it get tested. They want to see it get challenged in public. So part of the reason we're doing what we're doing at state level is to demonstrate to them, listen, this isn't as insane as it looks. We can actually make this work. Mm-hmm. And it can survive public scrutiny. So I'm optimistic that we'll get some federal action at some point in the near future. There hasn't been anything so far. But, we've seen reporting in the Telegraph that this is a key issue for the White House. The White House has indicated they're going to start issuing visa bans for people who cooperate with foreign censors. The Trump administration also leaked to the Telegraph, per their reporting, I don't know if the reporting is right, that they're going to start offering political asylum to individuals in the UK who are censored for political speech. So I think there's a lot of cause for optimism that we will see some federal action. And I think that would, if the federal government, if Congress lifts its pinky finger, right, then this ends overnight, right?
I can't imagine, so CNN, I think it was Dana Bash, had Marjorie Taylor Greene on recently, particularly after she, it's her, Massey, everybody's been pushing for this stuff. And, she's asking for toning down the rhetoric. And they kind of went to her and said well, you've been kind of overboard on these things. Mm-hmm. So you have that as one issue in the United States. And then I think on the swing side, though, I think most Americans are kind of either shocked or ridiculing what's happening in the UK in terms of arresting comedians, flying back from. Yeah. Would you feel comfortable going to the UK?
I won't set foot in the UK for several years.
Yeah. Because of this, you think you would be arrested?
I think I would be searched at the airport.
Yeah.
I think that my devices would be seized. And I think they would try to obtain information, as they've done for other. I mean, they did that to, for example, what's David Miranda, Glenn Greenwald's husband, when he was passing through Heathrow Airport en route to Brazil. They stopped him under the Terrorism Act and searched all his devices, made him disclose
the Terrorism
his passwords
Act
under terrorism charges. Right. So no, I won't set foot in the United Kingdom again until Labour is out.
What's behind this? Why did this happen in the UK to begin with?
It's because there's a group of managerial jerk-offs, people who go to Davos every year, who thought that
The globalists.
Globalists is, I don't like the term globalist because of it has certain connotations in other contexts. But people who think that the world needs to be harmonized around one set of rules and that they know best, and that national sovereignty isn't for them, and that people can't be trusted with basic liberties. Those people run the UK, and they run Australia, and they run New Zealand, and they used to run until about a year ago. They used to run the United States, and something like the First Amendment, which allows people to criticize their politics and their motivations and everything else that they do openly without fear of consequence, is very dangerous to them, and they want to see that eradicated, essentially. And they made that very clear, right? And you can see in Ofcom's letters that they sent to us, they have no respect for the First Amendment. They don't think it protects us. And we're going to teach them a lesson about that, because it very much does protect us. So I think there's an ideology which prevails outside of the United States, which views the first, and also they don't have a tech industry in Europe, and they want to hamstring ours. Seriously, I mean, we said that in our pleadings. And people,
they banned AI in Germany.
And they banned AI in Germany. They want to regulate American tech industry. It's just a clown show. They don't have an economy. Their energy is crazy expensive. They tax anything that moves into oblivion, even more than we do here in New York.
Right.
And it's something where it's just a terrible place to do business. So they want us. I mean, I guess misery enjoys company, and I don't want to see Europe fail, and I don't want to see the UK fail. I want to see them succeed. England's my favorite place in the world. It kills me that I can't go back because I have so many friends there, and I want to live there. It's my home.
Yeah.
But I've trained and qualified there. I lived there for 16 years. All the rest of it. But the fight requires me to be here. Right. And I'm not going back until such time as the people who currently run that place are out of power, because I'm 100% certain I would be stopped at the airport. My devices would be seized. They would seek information about my clients, and I'm not prepared to give that to them. So
it's heavy stuff. So bridging the gap a little bit to what's going on with Bitcoin, they're not direct First Amendment issues, but it is starting to touch on open source software development around the Tornado Cache, Samurai, BTC Fog, like the mixing. It's the other Roman. There's Roman Storm and the mixing Roman. There were charges that were not directly associated with First Amendment issues, because I think in all three of those cases there was some form of payment for a service provided, services rendered. So that was a good trigger, I guess, for the prosecutors to loop in AML, KYC. Money laundering charges because of payments rendered. A couple of weeks ago, we had two journalists, David Z. Morris, who wrote a book recently on, David's great, and Frank Corva were in here because they both went to the sentencing hearing for the Samurai Wallet guys. And David, posited something really interesting that I think, I'd love your thoughts on. You either do it Satoshi's way or you don't really do it at all. And the reason that I bridge this is because there's another Brit focused on First Amendment rights and free speech, Beautyon, Akin Fernandez. I know,
he's the best.
He is the best. And he was one of the first, him and Mircea Papachou, I don't know if this is totally accurate, but I think of them as the original Bitcoin philosophers.
I think Mircea Papachou, God rest his soul.
Hopefully it was just a disappearing.
Hopefully it was just a self-disappearance. But if not, God rest his soul. I think they both saw over the horizon and
for sure
got it more than anybody else did.
Beautyon's one of the drums that he was beating really hard was this is a communication protocol. This is speech, and money is speech, and the way Bitcoin operates, the way it was created and put out into the world, it should be protected under the First Amendment. It's not money, it's speech. So, as you're going through these things with Kiwi Farms, Gab, 4chan, and Sasu, with your background in Bitcoin and, cryptocurrency and blockchain technology and all those things, How do you think about that through line?
You bump into it all the time. So it's particularly with DeFi stuff. And the question is, are you engaged in protected speech or not? Right. Mm-hmm. And so the way that you wander out from protected speech is you start doing things, you start monetizing things, you start assisting people with closing transactions, you start, encouraging people to do things. So there's a big difference between just publishing code and letting it rip. Right. And then saying, okay, well, we're going to publish code and we're going to have a UI and we're going to host the UI. And in addition to hosting the UI, we're going to monetize it and we're going to get paid a fee and we're going to do this and we're going to do that. So every new problem that you have requires you to map, right, what the software actually does. Right. And then, so for example, Cahill, right, is a law firm here in New York. Mm-hmm. Lewis Cohen, he's a good friend of mine. He's one of the sort of deans of crypto law, one of the best. When I have a problem I can't fix, there are a handful of lawyers I go to, and Lewis is one of them. Mm. And so, they have an Ethereum dev, right, on staff at the firm to look at how the contracts work so that the lawyers and the developers can say, okay, this is the full map, right, of what we're doing here. And these are the little points of articulation where the law is going to bite. And so how do we go into those and pull them apart, disaggregate them, right, and look at every single moving component and determine whether there's legal liability arising as a result. So that's the exercise that you have to go through, right? Mm-hmm. So, and you go through it every time. And understanding where the First Amendment ends and where crypto and financial services begins it's a nuanced exercise. It's not impossible, right? You just need to learn the doctrine and get used to it. And generally speaking, it's fairly intuitive for any lawyer to know. It's like, well, are we publishing the software? Okay, if we're just merely publishing, merely writing, then that's one thing. But if we continue having touch points with it, right, you look at where those little touch points are, where you're steering it, right, what you're doing, where you're extracting things from it. And you say, okay, well, all these little things we're doing to nudge this little thing through as it wends its way through the world. That's potentially where the legal liability attaches. And right. That's, if you look at the Tornado Cash or the Samurai cases, right, it was the continuing ongoing touch points, right, not the publication of code, which is what got people in trouble. Whether it's right or wrong, right, as a moral, like whether it's right or wrong, right, that's the case is not a legal question, right? It's a moral question. And whether we want the trajectory of our law to permit, right, the sort of activities that these guys engaged in as they did, is a normative question. It's not a descriptive question. And there's a really broad multiplicity of views about, what happened and whether it should have happened the way it happened. But that's the exercise that if you engage with crypto at all, right, it's something that just comes up again and again and again and again. Is the thing that we're doing, even though it's mostly decentralized, right? Well, let's look at, I call it the space marmot test. Seriously, I know. Seriously, you've heard about this?
Yes.
The space marmot test is you and your startup, you pack up and you all decide, okay, we're leaving San Francisco. We're going to go to Tahoe for the weekend. We're going to set up camp and we're going to go do a little dev retreat, right? And as you're doing that, in high Earth orbit, the space battle fleet, right, of intergalactic marmots drops out of warp. And they determine that they're going to attack the planet and that your startup is the linchpin of the planetary defenses. So as you're sitting there doing your work, kumbaya out and your little dev retreat, all of a sudden you and your entire team, all of your servers, everything is vaporized by an ion beam from outer space, right? Or nuked or whatever else you want to call it. And the question is, did the thing you just built, right, does that still run? If yes, then probably decentralized. If no, then why? And then you list out the reasons why. And then you look at every single piece of the puzzle that got eliminated when you did and your servers did and your software did. And then you say, okay, well, let's look at those little pieces and what broke. And then we can determine, right, where the legal liability attaches and, how we maybe engineer those things out or approach the business from a different perspective or just go get a license, right? And say, we're going to have a compliance program, do AML, KYC and all the rest of it. And so that you see that a lot, particularly with the derivatives exchanges, right? Mm-hmm. That's a big question that comes up repeatedly, right? Is if you've got a DEX, right, that's trading in perps, right? Mm-hmm. Big question.
Hyperliquid,
right? Something like that.
Decentralized, maybe someday.
Decentralized. Look, I'm not gonna speak ill of another
it's
exchange.
The Bitcoiner in me.
But the question is, right? Unlike a spot DEX, right, where the rules are different, right, around money transmission, with a perps DEX, right, the fact that you're facilitating, the transaction in the derivative contracts, is enough, right,
Yeah.
for the Commodities Exchange Act to apply, whereas the Securities Exchange Act wouldn't necessarily apply to a spot DEX.
Yeah.
So the question is, what are the differences? How do you approach it? We've seen a variety of different approaches from a variety of different providers. I think there is, to a certain extent, you don't have to be perfect, but you just have to not be the slowest gazelle approach. But that's different companies have different risk tolerances, have different approaches to regulation, different approaches to compliance, things like that. And so they all make their own determinations, and then may the best man win. So but that's the kind of stuff where this comes up a lot. Mixers and things like Tornado Cash I had a client who came in and proposed to do something like Tornado Cash, but for a different chain once, many moons ago. And I was like, well, you should just delete the code and forget this ever happened. Like, I was like, just don't, right? This is not something you want to be involved with.
Right.
And I was perhaps overcautious, maybe not, but I think ultimately, given what we saw with the Tornado Cash case, I think that if you're going to do that, but then you have other approaches, right? So Amin Soleimani is working on Tornado Cash is interesting tech fundamentally, and so there's a way that you can use.
It's still running,
right? But you could use trusted pools and have an additional, authentication token. And Amin Soleimani was working on this to potentially use the same thing to provide a service that is BSA compliant, but also is a DeFi system. Right. So it doesn't rely on centralized infrastructure. And so it'll be interesting to see what, as a result of that prosecution and its results, what the trajectory is, right, of the industry as a whole, and whether we see a compliant DeFi solution where someone says, listen, this is just a really simple, like, you KYC yourself. We can do some monitoring. We can, we'll detect suspicious transactions and send them in, but we're not in custody of your assets. Right. And so you are in control of your assets. And is that a good thing? I think probably. But it's something where, it's such a complicated domain that getting it right is going to take quite a bit of time. So yeah, I mean, that's the stuff of day-to-day crypto law practice.
So I want to make sure that we have a little bit of a break before we start downstairs. I have two last questions, and they'll be bigger ones. I want to go back to the Beauty On post in terms of Bitcoin as a communication protocol, and it's quite dumb, right? Like, you're reassigning an amount of Bitcoin from one address to another. You basically speak that truth into the universe, and if it's accurate and it gets mined and it gets validated, that speech effectively has monetary properties because of other things that are going on in Bitcoin, right? Agree? Beauty On goes far enough to say, kind of the same way that the Second Amendment was almost applied. I don't think it was ever formally applied to the release of encryption, right? There was going to be a munitions case that was dropped before.
Encryption's a First Amendment issue.
There was a munitions defenses, but no. The munitions piece was raised by the government, but never pursued, I believe.
Raised by the government, but never pursued.
Yeah.
Ninth Circuit, Bernstein versus United States.
Thank you. Yes, exactly.
And it wound up, the question was, could you publish source code?
Yeah.
Right? And so the answer was, it wasn't, they didn't address the question of encryption.
The first protected the second.
Well, no, the second applies, the second applies to bearable arms, right? So it has to be a weapon that you can carry, essentially, is the Second Amendment. And obviously different states take different views about what's allowed and what's not, but generally speaking, bearable arms is Second Amendment. So encryption is covered by the First Amendment, but by proxy, because the First Amendment covers the publication of source code and expressing yourself through source code. So in Bernstein, they did not directly address the point, right, about whether encryption is covered by the First Amendment, but they said, listen, this is source code that is expressive, right, and therefore that's protected by the First Amendment, and therefore implied necessarily that source code which implements an encryption scheme is also protected by the First Amendment, even though it wasn't necessarily the core issue in that case. So with Bitcoin as a First Amendment critter, I think running a node, First Amendment protected activity. Hosting the software, First Amendment protected activity. Relaying transactions, First Amendment protected activity. Sending a transaction, just like for your own personal reasons, First Amendment protected activity. Providing services that assist other people in doing it where the primary purpose is not expressive, question. Right? Yeah. Question mark. So that's, as much as I'd like to say it's First Amendment activity, even existing First Amendment doctrine says, right, so if you're selling newspapers and selling books out of a bookstore, you still have to pay taxes, right? It's not necessarily burdening the speech itself. It's a rule of general application, which applies to how you're running a business. So there are circumstances where First Amendment protected activity, right? They can't go into your bookstore and tell you can't sell this book or you can't sell this newspaper because it's disapproved. They can't hold you liable right, for the content of the book or the newspaper. In a defamation case, it's Smith versus California, because that's protected. But what they can do is they can say you have to pay taxes, right? And your employees are entitled to be subject to labor law and things like that. So you look at things which are purely commercial, and those things, right, are what the First Amendment is not about, right? It protects expressive conduct. So Bitcoin is one of those weird things where it is a First Amendment creature, and it's possible to use it for First Amendment protected purposes. And if you interfere with it too much, you probably trample on the First Amendment at some point. It's just that we haven't seen a case, right, where the government has attempted to intrude to that degree where the First Amendment is implicated yet, right? Usually what you're seeing is a mixer, right? So a mixer is, you could argue, right, well, they're just providing communication services for people using Bitcoin and that sort of thing. Well, most mixers, they're also taking custody of the funds. They're then mixing them up. They're sending them out with specific intent to do a particular thing. And that's money transmission, et cetera. So it's a blurry line, right?
Yeah.
But we have
for a fee in many cases.
So it's a blurry line. But if you had software that did it, right, and you didn't monetize it and you just published it, CoinJoin, right, for example, First Amendment protected activity.
Yeah. What about block construction from a miner's perspective? What if you had made in America only mining operations that are, deciding what transactions get included in a block?
That's their business. Let's see. Good luck getting the
so at what point does an OFAC sanctions list and other things become, I don't want to say compelled speech, but when do you, in your mind, thinking about First Amendment as much as you have over the last couple of years, at what point do you start to run into the First Amendment critter, as you said? So
OFAC, I mean, you have sanctioned entities and you have blocked property. And basically it says that a sanctioned entity, you can't do business with them. You can't accept property from them. It's not something where I don't see that. I don't really see that interfering with the core operations of the chain. And there have been some circumstances, for example, where I believe during the Tornado Cash saga, right, they sanctioned the contract and then someone turned around and spent dust from the contract to every .eth address that they could find.
Yeah.
And of course, the way Ethereum works is that, it's not a UTXO based system. It's an account based system. So what you then had is you had hundreds of thousands of accounts, which had been tainted by this one account. And then ostensibly, right, because the assets had been commingled, they would have to go and apply for a license from OFAC to get it released. I mean, if that were the interpretation they took, I think that would be absurd. And that's the kind of thing which is readily amenable to judicial challenge. And they kind of just let it go. Yeah. I think the Vitalik.eth address, it's not that all of that Ethereum balance became blocked property because this dust got deposited into the account. So yeah, it is a relevant consideration, generally speaking. When you look at these situations, there's a reasonable interpretation which you can adopt. I'm not an OFAC or sanctions expert by any stretch. When it comes to those thorny questions, we have lawyers who help us with that. But yeah, they're all really interesting questions. You deal with them. You deal with them every day, right? Because you see, okay, a bunch of money was here. It got moved there. It got moved there. It got moved there. It got moved there. This address, right, was on a sanctions list. We know there are 10 intermediate hops, right? We don't know who any of these guys are. We know this person at this end isn't sanctioned, right? Yeah. And we know the person that they dealt with wasn't sanctioned, but it's conceivable, right, that there's a UTXO that started here, that ended here. What do you do, right? And so you have to go and look at the very specific facts of that situation and work it out. You could talk with outside counsel, you figure out what your obligations are, what the facts look like, and you make a judgment call, right? Do we have to block this, file a block property report, or do we have to file a SAR, or do we have to do this? So it's very, very, it's not simplistic. It's really complicated. It's super annoying. It's super fun to do. I mean, that's the more complicated and annoying it is.
The regulatory moats. Yeah. All right, last question. A lot of Bitcoiners look at the Bank Secrecy Act as the single worst act in terms of eroding constitutional rights. First, second, third, fourth, probably.
Yep.
The derivative of, I guess, those three or those four. That's the final boss, a lot of Bitcoiners say. What's the pathway look like? Is there any hope for, I would say, Bitcoiners and folks that are rediscovering how important these rights are? It's not just Bitcoiners. It applies to a lot of Americans, and I think it applies to a lot of people globally. But from what I've seen from PubKey and a lot of the conversations that we've had here, there is a focus on the BSA and the Patriot Act and how damaging it's been to some really, fundamental American rights. Do you think that we are moronic enough to make a charge against these things and actually make some progress? Because that's a third rail historically in Washington. You don't really talk about the BSA.
If you think the dragon must be slain, slay it. No one thought that 6 months ago, no one thought the Online Safety Act was killable. We're on the verge of killing it for good. Right?
Yeah.
We are very, very close to killing this thing. And if you went and talked to any law firm in London and said, the most expensive lawyers in the world, and you said to them, hey, I'm a tech company, I'm X, I'm Meta, I'm Reddit. I don't want to know, right, what Google and Microsoft and Meta and X paid to London lawyers, right, over the last 3-5 years to deal with Online Safety Act compliance. It will be in the hundreds of millions for sure. And then what happened was a handful, like 5 people in the United States, all solos, all lawyers, turned around, and we're this close to killing it for good, right? Because we looked at it and we said, this needs to die, and we're going to be the ones to kill it. So with anything right out there, you can charge into battle and you can stop it. And I'm very confident that with the Online Safety Act, that's exactly what we're going to do. When it comes to the BSA, but you have to wait for the right time and the right circumstances. Sure. Because remember, these are political questions. There are legal questions and political questions, and sometimes a question is both. With the BSA, it needs to make sense to get rid of it when we decide to make the charge at it and get rid of it. And I think that as crypto evolves, particularly with AI, I think the world's going to change a lot in the next 5 years.
Yep.
And in particular, you're going to need things like machine-to-machine payments, right? AIs doing work and having, tamper-proof money, because they're going to be really smart, right? And they're going to be able to hack all kinds of systems and penetrate all kinds of systems and fake things. But the one thing they can't fake, right, is a digital signature. However smart they might be. So from that perspective, I think crypto is going to become very, very useful. And I think the Bank Secrecy Act is going to become an impediment. And we need to look out for the point when the Bank Secrecy Act no longer makes economic sense for the United States, because it's holding back our ability to expand and grow. And then that is the point to make the charge. So for us, the Online Safety Act's been a thing for 5 years, effectively, right, in one form or another. So same with the Digital Services Act. But we had to wait for the right time to go charge into battle against it, because activists have been screaming about this for years and years and years and years, and they have been trying to stop it, and they haven't been able to. Well, we figured out the moment that you can stop it, right, is when they try to enforce it, and then they can't. And then when you do, you say, haha, watch this. We're going to prove that your law is toothless. And that is the first step in making a law inapplicable. So with the BSA, it's the same thing, right? People who want to, you have to find someone who's very, very passionate, probably with a law degree. And you have to figure out plan ahead and understand, right, where are the collision points, right, where this law is going to start really holding back the American tech industry. And then once you can see those, and with crypto, for sure, it's already happened, right? Yeah. But I think we're going to see more conflict as we go forward. And then I think what we do is map out where those collision points are. And when it gets bad enough, and when it gets painful enough, and when it gets difficult enough, that will be the time to go after it politically. But I don't think we're there yet.
I love it. Maybe it's your next dragon. How can people help support you and your quest to kill this dragon?
How can you support me in my quest to kill this dragon? Never give an inch. We got this handled. I think it's
grassroots. Wyoming, New Hampshire. Talk to your representatives.
If you have a state rep who wants a copy of the Wyoming bill, it's not public yet. Let me know, and I'll get you a copy of the bill. And,
I would like a copy.
I'll get you a copy of the bill. And if you have a state rep who's keen to do this, get in touch with me. I'm easy to find. ByrneStorm.com, contact form on there, and just or PrestonByrne.com. There's a contact form there, and just ping me a note and say, hey, I've got a state rep who wants to take a look at the bill. But it's already, this is already moving under its own power. It's already with,
I love it,
cross-state legislative groups. So really, I think the only thing for people to do is sit back, make some popcorn and enjoy the ride.
Awesome, Preston. Thanks for coming in.
Thank you for having me.
We'll leave it there. All right. We'll see you downstairs, and tip your bartenders.
Outstanding. Awesome.